Good morning friends. Welcome to my YouTube channel Advocate Amit Kumar Gupta. In my series on the income tax cases, the case which I am going to discuss today is Renaissance Services BV versus Deputy Commissioner of Income Tax. This case has been decided on 21st April 2022 and matter has been reported in 445 ITR at page number 27. The matter has been decided by Bombay High Court. The facts of the case are very interesting. This case is about section 144C. Section 144C says that if the department is going to make some variations into the income of the assessee, then the department has to issue a draft assessment order to the assessee. And when the assessee receives the draft assessment order, then the assessee has to file its objections to the variations within 30 days from the date of the draft assessment order, or has to intimate to the department that he is going to accept the variations. And department has to pass the assessment order within 1 month from the end of the month in which the assessee files its objections or chooses not to file the objections. In this particular case, the department issued the draft assessment order on 19th April 2021. So the assessee has to file its objections up to 18th May 2021 or to accept the variations. The assessee sent an email to the officer on 17th May 2021 that I am not going to file any objections and I will fight this case into the normal appellate proceedings. So, according to the facts of the case, because the assessee has filed its objections and given as consent to the variations by saying that I will fight it into the normal appellate proceedings on 17th May. So, if we go by this date, the department has to pass the order within month from the end of the month in which this intimation is received by the department. So, the department received the intimation on 17th May 2021. So, the department has to pass the assessment order up to 30th June 2021. But in this particular case, the department passed the assessment order on 27th September 2021. Meaning thereby that the last date for passing the assessment order in this particular case was 30th June 2021, but the assessment order was passed on 27th September 2021. So this was out of the limitation period. When this matter travelled to the Bombay High Court, Bombay High Court said that according to the section 144C, there is no doubt that the assessee has sent the mail to the department for intimating to the department that I am not going to fight the variations at this stage. I will fight these variations at the appellate proceedings. So, according to section 144C, the assessment order has to be passed up to 30th June 2021. But the department passed the order on 27th September 2021. So, it was out of the limitation period. In this particular case, the department was relying on the circular of the CBDT, the circular number 8 of 2021. In that circular, some extension was given to the assessee for filing his objections. But the department was taking the benefit of that circular and saying that my period is also extended by that. But in that, if we go by that circular also, in that circular, the time limit for filing the objection was extended and that too was also up to the 30th May 2021. But the department was using this circular for extending the period up to 27th September 2021. So it was height on the part of the Deputy Commissioner of Income Tax. So the Bombay High Court in this particular case quashed the assessment order and said that this order is null and void, and it was not any remanding back or something like that because the time period was over. So now the department cannot pass the assessment order. So in this case, the decision was given into the favor of the assessee. From this particular case, we get a teaching from this case that sometimes we fight the case on the basis of the merits, but we have to see that whether the notice was issued on time, whether the assessment order is made on time. So these facts are very important. So we should evaluate all these things before making our grounds of appeal, so that we can take the benefit of these grounds also. At the end of this video, I am repeating the name of the case. The name of the case is Renaissance Services BV versus Deputy Commissioner of Income Tax, and this matter has been reported in 445 ITR at page number 27. Matter has been decided by Bombay High Court, and this case is decided on 21st April 2022. Thank you, friends.